Good morning. Today we're talking about war-related crime investigation of the Russian. So today we understand that this war crime should be investigated a lot. There are a lot of issues, and today we will have very specific discussion about it because we are based on legal experts, investigations, and research. And also, we have a lot of different law enforcement bodies representatives that will tell us about their challenges they meet and face in everyday work. My name is Volodymyr Yavorsky. I'm the program director of the Center of Civil Liberties. We have it together with the Ukrainian Association of Human Rights, International Fund Renaissance, Відродження, and also together with the EU support. We understand that all that we talk about today is our position, but our event is also supported by the EU, and this is a very good sign. So today we will have two different parts of our event. First of all, we will present the research of the Ukrainian Association of Human Rights that is relevant to the issues of the war crimes in Ukraine and their investigation. And after it, we will try to have a discussion on this topic about issues that are shown in this research and maybe some other issues that also can be relevant for law enforcement bodies. We do believe and we are convinced that this dialogue should be a permanent one. It should be targeted for the resolution of different issues because there are a lot of them, and we should do it in a correct way to provide and to ensure the better investigation of the war crimes. So in our time frame, we have two different panels. The first panel, we have Roman Romanov, International Fund Відродження, Alexander Pavlichenko, the Executive Director of the Ukrainian Association on Human Rights, Oksana Filipishina, also from the same association, and also Vladlena Padun, the analyst of the Ukrainian Association on Human Rights. So there will be speeches delivered. Each of them will be 5-7 minutes in the timeline. And after there will be some comments or maybe questions. After we will pass to the next panel. So first of all, Alexander Pavlichenko, the CEO of the Ukrainian Human Rights Association. Dear participants of the presentation, first of all, I would like to express my appreciation for the fact that you also enforced and supported this research. Thank you so much for it. And also thank you to donors who supported it. Thank you also for all other people who were engaged into the field visits, the General Prosecutor's Office, National Police of Ukraine, whose representatives are here. And also these are legal experts of the free legal assistance that also filled in different templates and questionnaires and focus groups, and also the possibility to work over this is really very important for us because this goes from you, and you face this 438 article of the Criminal Code on daily basis, and it gave us possibility to see all the challenges and problems, and we formed also some potential recommendations that can be also one of the targets for some practical implementation and improvement of the system. We work together with our law enforcement bodies because we understand that there are a lot of different massive data in this regard, and also the over lump sum is more than 200,000 of war crimes, and this number is increasing, and we should understand, we should know how it will give us possibility to bring to accountability war criminals. Thank you so much to the fund Vidrodzenia that supported this process and continues to support it. Starting from the year 2014, when we also had the modeling research under the conditions of the armed conflict in 2014. So we did our best to continue this pace and track, and I'm really thankful and grateful to all the team who were very professional in the timeline of this work. And also to wrap up, I would say that this analytical report was decided to be dedicated to the members of law enforcement bodies who were killed during service. And this is our tribute to their memory. And also, we show the result of our work, and we appreciate their input because they helped us to investigate this war crime. And this is the element of the memory that should be engaged. Thank you, Alexander. Thank you. You said and you mentioned the International Fund Vidrodzenia, and I give the floor to Mr. Roman Romanov, the representative of this fund. And since 2014, he has been supporting a lot of different initiatives, more than dozens of them, that were related to the investigation or documenting the war crimes, and a lot of initiatives that today are there. They are operable and they are enlightened just because of the work of this fund. So please, the floor is yours. Thank you, Volodymyr. Thank you for all of you. I understand that it's not so warm here in this hall, but I do believe that the attention to this event is really very justified. You know that our fund is one of the biggest charity funds and organizations in Ukraine, starting from 1992. And we work together with public organizations, with state organizations. And the issue of justice and accountability for war crime is the streamlined topic for us. In the most difficult times and conditions, it's really very important for people to understand that justice is there and we should fight for it, as it was mentioned by public speakers. But I would like to make it possible that today it is not just the public speaking topic, but it is a professional work all over the Ukraine. And a lot of people dedicate their time and efforts to it. And this is a unique topic because, as a rule, people who suffer from aggression, from big threats all over the planet, they do not have capacities and capabilities to investigate by themselves war crimes. So generally, this work is done outside the borders of the country that is affected. Some institutions are created, established, the data are collected, and some cases are built up relevant to the best practices of the country. But we understand that the practice all over the world is very slow in its development because people who are affected by international crimes, they understand its postponed reaction. And based on all this, and starting with Starting from 2014, Ukraine from the very beginning stated that we would like to investigate everything that has been happening in the framework of Ukrainian jurisdiction. So from one point of view, it was quite a bold move. From other point of view, we understand that this step should be enforced and supported by the institutional capacity, by legislative framework that makes it possible to implement this intention. That's why I do believe that from the position of public organizations, it's really very important from time to time to see what's happening, because we all are supporting this intention. But we should understand what obstacles are there and how efficient is the work itself. Because the intention that cannot be efficiently implemented leads only to frustration and despair. And this is the last thing that is needed for Ukrainian citizens. Now, if we look more globally, besides national jurisdiction of Ukraine, there are a lot of other institutions that help, assist, or even autonomously work over investigation of crimes in Ukraine. I do remember that starting from 2022, there was a great enthusiasm from International Criminal Court, but recently we hear less and less about the operability of this institution. It doesn't mean that this institution stopped and terminated their work, but it means that the international situation is the following: that this court itself is under the big political pressure, unfortunately, and it means that we all are interested in its further work. We should help this work, but we shouldn't have very high expectations, because the capacities of this type of investigation will increase is very least probably. Also, there were a lot of expectations about the universal jurisdiction of European countries, and sometime later we saw that due to different reasons and due to the fact that Ukraine declares that Ukraine has its own capacity and capability to investigate a big part and big share of the committed crimes, and due to the discretion character of these investigations in the framework of universal jurisdiction of a lot of countries, we do not have a lot of progress here, though some facts that are really very positive. For example, we have the conviction in Finland for the person that was engaged into war crimes in Ukraine. Also, the detention and the arrest of the archaeologist, Russian archaeologist from in Poland, that worked a lot in the Autonomous Republic of Crimea and the city of Sevastopol. So we understand that this initiative is really very pivotal. Nevertheless, due to the fact that most work is done by the prosecutors, legal experts, lawyers, and courts in Ukraine, we should understand where we are, what are the entry points for different efforts, for different initiatives, which expectations can be just in this moment. And it's really very important for us not to let people have this frustration, because people count on the fact that there is justice. Thank you. Thank you, Roman. Thank you. I would like to say that we have also simultaneous interpretation for our online and offline participants. So please, you can use the headsets offline, and online there is this special button interpretation. So please feel free to use the channels. So now we will pass to the research of the Association of Human Rights of Ukraine. So it is in two languages, in Ukrainian and in English. So all people who registered for the event, we will send this research to you together with presentations. That's why no reason to be worried about it. And now I give the floor to Vladlena Padun, the analyst of the Ukraine Health Association of Human Rights. So together to the previous speakers, I would say that yes, you can even scan the QR code and there will be the link for both versions, Ukrainian and English one. First of all, I would like to start from the fact that the pretrial investigation for our co-authors was an issue for us and a challenge because first of all, there is the substantivated legislative requirement for the secret of investigation. Then there is the question, why do we work with this pretrial investigation? And the answer to this question is the following. Frankly speaking, a lot of our colleagues focused their attention properly on the analysis of the decisions. And pretrial investigation was always in shadow, but here we see the foundation for the accountability and responsibility. And we wanted also to hear from people who work in the field to understand what are their challenges, not some external results and consequences that we see and we observe here. Also, I would like to give you the general framework to make it possible for you to understand where we started and what were our basics, what were our goals. First of all, I would like to say that we tried to achieve the goal to analyze what are challenges faced by our law enforcement system in the context of investigation of war crimes. And the object of our research was the state of pretrial investigation in these criminal proceedings. So we thought a lot about the fact how we would be engaged into this investigation and into this research. And thank you so much to our prosecutor's office, to the law enforcement bodies, to national police and the free legal assistance, because they helped us to have the questionnaire and to conduct the research, to see the visions and thoughts from different people. Also, we analyzed a lot of different academic publications, papers, some media posts, and other sources. And also, we couldn't go without the analysis of the unified register of the pretrial investigation court decisions and the relevant articles of the Code of Ukraine. And also, we addressed law enforcement bodies to understand what are the scales, because sometimes we understood where we can find some statistic operation, where not. And if we talk about our respondents, there were 181 law enforcement bodies, 64 prosecutors, and 117 investigators, and also 44 lawyers who work with war-related crimes. Thank you for being engaged into our research.
Thank you, Volodya. Glory to Ukraine, and we are part. We want to highlight the results and answers on organizational questions in order to more or less see the portrait agency which we have for today and who's involved on pre-trial investigation. And the second block of presentation is concerning the right of law application, what our law enforcement deal with, or procedural laws in order to be more clear why we have such a big difference. You will see the slide at the end, and a big difference talking about the number of these documents registered under the 480th article, and those cases which go to court. In order we could hear and start with the basic things. Today you have already heard some numbers concerning a huge number of criminal cases registered according to this article, as it was 185,000 and more. And you know that recently were published by General Prosecutor's Office, and now this number is much higher, is more than 200,000. What I would like to add concerning investigators and prosecutors, the positive thing is that investigation is done by specialists who work in specialized departments of both systems, in prosecutors department and investigation department, and the specialization was done following criteria which we were informed by law enforcement agencies, talking about those students which are within some regions closer to frontline, or those who are suffering because of shelling by Russian Federation. And this specialization was assessed positively by prosecutors, and more than 85% of respondents mentioned the positive side of this specialization. Concerning human resources, it was interesting to find out about their experience talking about law enforcement workers. And as you can see, there is some anxiety as prosecutors and attorneys may have proper experience in observation and protection, more 3 years. It's 40% of attorneys and 60% of prosecutors who have experience more than 3 years. We have a little bit different situation with investigators. 22% of such investigators have such experience of 3 years, and the fourth part have the experience less than 1 year. So it was interesting for us how the workload is being divided, what are the criteria being applied, and the investigators highlighted 3 main criteria within this unit. On this slide, you can see the answers of investigators and prosecutors, and there is some difference. So depending on qualification requirements and the number of cases, and depending on experience and qualification. So there are some objective and subjective issues, and we can come up to conclusion that among the representatives of law enforcement agencies are about how many cases the person has and what experience. Talking about prosecutors, what is the workload is on workers depending on the qualification size of cases. Also, the workload which investigator or prosecutor have, and here you can see that 67% of prosecutors do the procedural management in more than 100 cases, when more 100 cases per one investigator is on 27%. So there is some disproportion which can influence on the quality of prosecutors' observation. So what is needed to our law enforcement agency, and mainly everyone come up to conclusion that very common obstacle in their work is absence of vehicles, in particular armed vehicles. So not just our army needs that, and law enforcement work said about the lack of individual workplaces, which influences on the quality and effectiveness of their work, and also the personal protection items. So more than 50% of respondents, 60% consider that communication is not effectively enough or not sufficient. Also, the attorneys mentioned that communication with the law enforcement agencies is pretty low. And it's also about 45%. Talking about challenges, it's clear. It's first of all access to the evidence proof database. It's to the area of crimes, so those in those occupied areas, or to those who are suspected or victims. Also, there was coincidence of questions and answers concerning of pre-trial phases and factors which have influence on them. As I mentioned, it's about 85% of prosecutors and 61% of investigators. It's a big workload per person. It's about 72%, and also the absence of access to the suspected. I want to pay your attention to that 10%. If to sum up, talking about respondents, they paid attention to having like manual management of process from command, and 20% of respondents mentioned the absence of experienced specialists, which makes the process more complicated and delayed on accomplishing the expertise. Also, I would like to pay attention to the same 20% mentioned on obstacle, such as not good enough laws and lack of experience. Concerning the block of questions concerning the application of laws, it was about 216 article of procedural code of Ukraine was about security service of Ukraine, and we have a part 10 of this article which enables the prosecutor change this procedure, and it leads that a third of criminal cases are being investigated by the agencies of national police, and the issue is to our mind the application of this 438 article, as we have the law on ratification of Rome Statute, and last summer this article had changes, so it's the third transformation of this article, and it turned out that the changes in 438 is about making it wider concerning what previously qualification was previously had a little bit different when war crimes were committed, and now it's more wider what could cause the death of a person. So it gives easier tasks for proving what caused the death of person, but nevertheless it doesn't influence on lower number of those cases. And as I mentioned, this article was amended concerning crimes where the victim was a child. We talk about the deportation, recruitment of other children. Concerning the these complication things of these cases, 30% of prosecutors paid attention that they face difficulties and the qualification according to 438 article, and possibility to divide it from separate it from other articles, or in complex of combining other articles of a criminal code. For example, talking about attacks on infrastructure of or massive weapons appliance. I'm trying to speed up because I want to tell you more. You will have presentation. We want to hear to other speakers. So those cases under 438 article, maybe you know the statistics, maybe you don't know, but you will see at the end talking about the massive number of these crimes as for the end of year. And those acts which were sent to court, we understand that within those 4 years, there were not so many final decisions, and the investigations are ongoing. So, as to our mind, except the general framework of 229th article, which talks about the time frame of investigation, there is another article which enables to continue investigation, take in consideration the complicated phases of the case. And answering the questions, what is a unique complicancy? There is no answer in the laws. So I just have 2 more slides. I'm trying to speak very quickly. In absentia, when we don't have access to the suspect, when they are outside the controlled part of Ukraine or on aggressor's territory. So we are talking about the absence of such measures. So right now we see that different forms are being applied. For example, a message are being sent as sending information in messengers through social networking, or a message to official profiles of military units or state bodies which committed a criminal situation. So it's like a rhetorical question concerning the information which is being published in official website. I don't think that Russian criminals read our newspapers. And my last slide, what was mentioned before, is concerning if our investigators and prosecutors take into consideration those documents and those documenting which were started from the first days of full invasion by NGOs. You know that there are some coalitions like tribunals for Putin and so on. And it would be very nice if, as we one of such organizations, we would be very pleased to say that 10% of investigators and prosecutors mentioned that they do use the data of such coalitions as a source of a criminal, of a war crimes. And this data is being used during pre-trial investigation. To sum up my presentation, I want to say that our main purpose was to unite in one document all those challenges and obstacles which we are facing now on the way to effective and justified punishment who committed a war crime, and in order to reach to our government, to our highest levels, and make the situation change for better, as our law enforcement workers and prosecutors need such support, not just on a level of organizational level, but also talking about training, but also on improvement of laws, which influences a lot of things, in order everyone could take the responsibility.
Thank you so much. I give the floor to Vladlena Padun. She will talk about the peculiarities of the criminal proceeding, and it is the last stage of this process and its logical consequence of the previous stages. So here we see what are the challenges are here and how we can resolve them. Thank you, Vladimir. I think that I want to say a couple of words for our lawyers. I want to drive your attention to the fact that generally the answers of the lawyers that represent people and defend people in criminal proceedings, they are generally correlated with the answers of investigators and prosecutors. Why do I drive your attention to this fact? Because it gives us possibility that both investigators and prosecutors were sincere in their answers, and the lawyers can convince us in this. What I want to drive your attention to is the fact that yes, the lawyers say that there are some difficulties in communication, and also what's a good thing that investigators they take into consideration the involvement of the defendant and representative. Still, there are some cases when the prosecutors and investigators they do not take into consideration the defendant or a representative. And also another fact: lawyer today is the procedurally independent, and he is entitled also to collect evidence, and that's why he or she has a challenge, because they should also defend the war criminal, and they should like suppress the inner emotions and being neutral and professional. But if we talk about this procedural autonomy, 50% of lawyers think that it influences the full set of the evidence. But also there is quite a remarkable number that think that it's difficult for them to say yes, and this is correlated to the fact to the question that was presented by Ms. Oksana about the fact that lawyers are convinced in their experience and background, and they think that it is sufficient to defend war criminals despite all the external and internal conditions, because only 65% of people are convinced in their background, educational background and experiential background. 35% are doubtful about it. And this is a big challenge for all the educators and donors, because lawyers, they have a lot of fighting inside of their personalities, but also we should help them to raise their awareness at the expense of those who already have had some experience. So we should help them. And also I will pass to the next slide when we talk about the court consideration. Here we see some drastic numbers. For example, as of 30th of September, more than 85,000 criminal proceedings. There are only 446 convictions for 742 people under investigation. And here we see the disproportion, because verdicts are not so numerous. So we see that there are only 155 against 202. So here we see it seems that maybe pretrial investigation system doesn't cope with the load, and its workload is, or its efficiency is quite low. Because here we see that maybe this is just 35% of efficiency. So on the conditions where we live, it is quite a good sign, but at the same time, we do not take into consideration our researched factors. That's why today we cannot get information about number of investigators and prosecutors who work over war crimes, because this is the top secret information, but we understand that they have very big workload. And yesterday, as of yesterday, there are 185 verdicts in the unified register of the pretrial decisions. So we see that the discrepancy increased by 30 cases, 30 verdicts. But for the half a year, we see the great difference between more than 185,000 and 210. Yes, thank you. Thank you, Vladlena. I have one question. So you said that there are a lot of gaps, a lot of challenges, but I would say that maybe there are challenges faced by the law enforcement bodies, because we understand that investigation of the war crimes is quite a very difficult case. So these are not general, not regular cases. They need a lot of resources. They need a lot of effort. But we understand that we have investigate them because they do not have separate terms of validity. And that's why here I have a question. For example, if we take the year 2026, 2027, how do you think we as the state, as authorities, what should we do to overcome some separate challenges mentioned in your research? So who is willing to respond? But please up to 3 minutes, because still there are some time limits for us. Yes, frankly speaking, I would say that first of all, we talk about the enhancement of the human resources, because you see the statistics about workload for one representative of law enforcement bodies. And as for me, this is the biggest challenge that can impact negatively the investigation, because if on your table there are 100 cases and proceedings, I think that at least 3 months are needed to read through each case. This is one situation. And also we are talking not only about the numbers, but also about their trainings, about enhancement of and readiness of their awareness and capabilities, and the provision for them with different means and tools for the documenting and making access to the crime scenes. So it is also related to the improvement of our legislation, because the 1/3 of respondents, they face the situation that they need improved and demanded legislation, because it impacts the qualification of the crime and the further investigation. So the enhancement of human resources and improvement and amendments of the legislation. Okay, something else? Briefly speaking, I would jump in here. I agree to what Ms. Oksana has said. And also I would like to say that, yes, here we're talking about the change and amendments to the Article 438. There are different proposals. Now we work over them. The question, how efficient will be the processes of the approval and amending this article, and how they will properly facilitate and change and positively impact on these statistics, and how they can maybe facilitate the work of the law enforcement bodies. This is the first thing, and also the consideration of cases in absentia and verdicts in absentia in the framework of legislation incumbent one that we have. So also our different judicial powers, they work over it, about this category of these criminal proceedings, in absentia. But also here in the statistics that was stressed, most verdicts are in absentia. So 80%, more than 80% of these verdicts, they are in absentia. So without presence of the people who were under the investigation. So here there is the question about the justice of the proceeding and procedural impact of the court processes. So here we see that we should consider it also separately. Okay, maybe any questions from the audience? Good morning, Andrei Kachmuradov. The public organization 29th December. Thank you for your research. I would like to say that if you say about challenges that appear on the way of the investigation, I think you have forgotten one category. These are the victims, people who were affected. So I think maybe it will be the topic of a separate research. But I do believe that there are some obstacles and challenges for the investigation. So this is the first thing I wanted to mention. And also my question, have you researched the statistics before the year 2022? And maybe there are some interesting facts that probably were different and distinctive from the statistics after 2022, because this is a bit of topic now, but the affected people and victims till the year 2022, they were discriminated in some moments. For example, about the national program of e-Відродження, they cannot submit their application. In the register of losses, they also cannot submit their applications. Thank you. Thank you for your question. Yes, we discussed about the periods that we were researching. And yes, in the presentation, there is absent this information, but it is written in the research itself that we took the period starting from the full-scale invasion, because Alexander at the very beginning said that the Ukrainian Helsinki Union for Human Rights, in this big track starting from 2014, there was another research that was mentioned also by our organization. That's why we decided to conduct the research properly for the period starting from the full-scale invasion. And yes, we understand that maybe not in depth, not in the large context, but somehow the victims also are mentioned in our research. And also about the victims and affected people. Yes, unfortunately, due to the lack of time, we cannot present it here, but in the research you can see about the representation of the interest of the affected people and victims. It was also written in the answers of the lawyers, and also the involvement, the percentage of the involvement of the victims to investigation activities is quite a low one. So yes, we fixed ourselves more on other moments, but also there are some information about it. Thank you so much. Thank you. Maybe some other questions?
I'm concerned about the workload, and I'm asking myself what is being done. You have talked about universal jurisdiction on EU level to counter and to help the Ukrainian investigations in that, and I'm also thinking of the principle of complementarity of the ICC. Is there anything being done to relieve the workload, the tremendous workload as we see in the statistics of the Ukrainian investigators and prosecutors?
Thank you. Це було питання.
Yes, thank you. It was the question about the universal jurisdiction of the investigation of war crimes in the frame of the EU. So we understand that there are a lot of, due to the complementarity principle that is in the Rome Statute, the national jurisdiction is the basic for the investigation of international crimes. So what is the assistance from European Union do we have? Frankly speaking, yes, you can hear the interpretation, yes? So I will speak Ukrainian. So here I would say that in this research we were not studying it so in depth. But as far as I know, I count on the principle of universal jurisdiction. Unfortunately, these principles are not very efficient, and Mr. Roman has already mentioned them. And unfortunately, we cannot ignore it. And we cannot depreciate the work of International Criminal Court, ICC, but the Ukrainian Helsinki Union for Human Rights and our initiative Tribunal for Putin, all the employees, they sent a lot of different requests in the framework of the Article 50 to the prosecutors of International Criminal Court. And also there is interaction from the side of Ukrainian law enforcement system with other law enforcement systems of foreign jurisdictions. And we do believe that there will be this interaction, especially in the framework of bringing to accountability of criminals. Also, we cannot ignore the support of international partners, especially when we talk about trainings, about some new exchange of experience, when we talk about investigation of war crimes. And also, I cannot tell you about the judicial system, but I do believe that also international partners, they also share their background and best practices with judges. I do believe so. Also, I cannot say that properly we can take best practices of other countries and properly apply it for our context without any changes, because we understand that there should be these adjustments to the martial law realia, because Mr. Roman has already said that we live and we investigate, we bring to accountability during the ongoing war, not in after-war period, but during the war. And this is a unique context, unique model. And I do believe that maybe soon Ukrainian model will be an example for future conflicts. I do believe only in theory. And also I will jump in here. I think that these are separate topics. For the communication, I mean ICC and subsidiary character of the assistance they can give. Unfortunately, capacity and capability of the direct collection of evidence during the ongoing armed forces isn't very high. That's why maybe ICC, they more count on Ukrainian law enforcement bodies when they build up their cases, not vice versa. That's why, from the point of view of the field work of the assistance, I do not believe that there is a kind of help, but also to build up maybe some streamlined cases and proceedings where the experience and best practices possessed by the ICC is very evident. There, I think it's really very pivotal for us. And for example, the case that is investigated about the shellings over the civil infrastructure, that includes also healthcare system, agrarian sector, because we see that there are ongoing attacks towards these sectors, and also energetic infrastructure, because we even feel it here while we are sitting here because of the cold temperature. So I think that we all Ukrainians, we should support it as much as possible, and we should support ICC because this international investigation is really very important and essential for all of us. About the universal jurisdiction, I would say that it is split into some clusters. With some countries, we have joint investigation team, but the number of countries is quite limited. Most countries that are capable of doing it, they are not inside this team. That's why there is no like common or joint planning of the resources or strategies, because all these countries, they decide by themselves during their jurisdiction how they build up their plans, and they also try to collect material from Ukrainians that has left Ukraine and went to other countries. That's why when we talk about the documenting the victims of war that are on the territory of other countries, it is efficient. From the point of view of accountability and efficiency, it's very far from practice and reality that was created by some European countries as for Syria. So there is no such efficient work. Mostly it can be justified by the fact that Ukraine says that autonomously they can investigate by themselves.
So why do countries of the EU have to spend the resources if a country can do it by themselves? So I think we need better cooperation with European partners. We understand the scale of crimes and the resources which are available for effective investigation and bringing to justice should be done together. I think we do have joint efforts and work. It's ICPA, it's the International Center of Investigation of Aggression against Ukraine. There are groups of prosecutors which work together under the EU. There are Ukrainian prosecutors. And I think there is a very nice team with the experience of Polish prosecutors, Lithuanian, so they work together. You will see the end state of that, but there is such a platform where they combine and join their resources in order to work together against this aggression crimes. So this work looks differently. Of course, we have a lot of place for improvement. We have need and possibilities for that. Thank you, Roman. And that the fear of aggression maybe motivates people, maybe makes people move. Thank you to the speakers for wonderful speeches. It was a very nice research of Ukrainian Helsinki Human Rights Union. Now we are inviting another speakers. Lysenko, he is the Deputy of Department of Armed Conflict at the Prosecutor's Office. It's pretty cold here. You can wear your coat. Christina, he's the chief of the Department of Investigation within armed conflicts from National Police. Alexander, he's the chief of Coordination Center on Legal Aid. Konstantin was a part of Expert Council on Public Freedom. He's a member of a working group who works in General Prosecutor's Office and on projects concerning changes to the laws concerning the Article 438, which talks about war crimes. I know that you have received this investigation. All of you received it before. You must have seen the results. So please share your thoughts, your vision concerning it, because a few days ago, General Prosecutors published his analytical statistics on an investigation of crimes for the previous year. So we will start with Mr. Lysenko, responsible for such war crimes at the Prosecutor's Office. Thank you. Good day to everyone. First of all, I want to say thank you to those who take part in the creation of such investigation and to the donors who are trying to support and investigate this very important topic of international crimes at war in Ukraine. Yet I had possibility to learn this investigation. I want to say that we, as a prosecutor's office, we agree with those provisions which were highlighted there with conclusions and recommendations. Of course, some of them are more relevant, some less relevant, but all of them will be taken in consideration by us during the time of planning of a future work and our future strategic documents and updated strategies on the prosecution of international crimes. Shortly, I want to talk about those questions, issues which we consider very important. It's concerning the big workload on investigators and prosecutors, and not enough resources of providing the proper and maximum research and investigation in all criminal cases. As it was mentioned today, a lot of prosecutors have a workload more than 100 criminal cases, but it's only because in this questionnaire there was no one option of answer for saying the numbers of workload. I want to say that the workload of less than 100 crimes for prosecutors are only in central departments and in Odessa prosecutor's office. Other specialized units have workload more than 1,000 criminal cases per one prosecutor. The highest number at Donetsk Regional Prosecutor's Office, it's about 4,000 per prosecutor. And this workload critically influences the effectiveness of work, because there are a lot of procedural aspects which take too much time, and instead of thinking of scaling up, we have to pay more attention on that. So we work with this very actively. We are looking for methods on how to make an impact on that. Also, the proper experience of prosecutor matters, the training of case management matters, and proper knowledge of international humanitarian law, and also the approaches of national experience should be applied. Also, it has been mentioned that the secret information concerning the number of prosecutors who deal with investigation towards international crimes, it's not a secret. There are 90 prosecutors in central agency concerning the most complicated criminal cases. And in specialized units, it's about 100 prosecutors. But unfortunately, we don't have enough human resources in specialized units in regions. Also, I should mention there is no regional prosecutor's office, which doesn't have, each of them has war crimes, and there are such cases on the regional level. We may think that the number of prosecutors who participate is much higher because each regions are involved more or less, but those regions who have specialized students are more involved. Concerning the challenges which have been mentioned, concerning big workload, there is a lack of resources. First of all, human resources, because the number of cases and prosecutors is very different, and the number of technical material resources. We need to provide basic needs for prosecutors in order to provide safety, like personal protection, vehicles. Also, it is important to provide with the technologies, because we spend a lot of time on paperwork, and technologies are very important in our work. Among those problems and issues which you have already heard today, there is essential obstacles that we very often don't have access to the location of crime or the location of victims, and we have to use some modern approaches in order to do this investigation, not having access to that location. What concerns the changes to the laws, I think Konstantin today has already mentioned. For me, it's not a very big challenge, but we always see a space for improvement. And as for now, we are preparing on the changes to the criminal and the procedural code of Ukraine. Concerning timeline, I don't see problems in that. The same as I don't agree with what was mentioned, that the 10th part of 216 article was applied for resolving cases. We use the fifth part of this article, where prosecutors can change some points in laws if there is no possibility to provide investigation effectively. So all sentences under 438 article, they go through the security agency, and then there is a decision to pass this case to National Police Agency. So it happens, and it's very good that we can divide our workload of a pre-trial phase, because we can't provide effective work on all areas. So I will stop here. I can talk non-stop about the challenges. If you have questions, we can talk later about that. Thank you. I think it's very important to start with. I will invite Christina. She's the chief of investigation of crimes within a war crimes from National Police of Ukraine. I was impressed with the number, which that a third of cases are being investigated by National Police. I've never heard this number before. So it turns out that it's hidden information, but National Police is doing that. It's nice. So could you share your impressions? Good day, dear colleagues. First of all, I will not say something special. I want to say thank you for invitation for National Police, for the main investigation department. The report, I want to talk about honesty mentioned in that report and openness. You could see that about 117 other investigators dealing with armed conflict were answering those questions concerning challenges which we deal with. And the previous speakers mentioned a lot of challenges we have to face. It's not a secret that National Police always have to go to the locations of shelling in order to document the cases, and also investigation involves, since full invasion, we are being involved. National Police has two departments who are dealing with this investigation on all territory of Ukraine, and 12 specialized sections, mainly at the frontal area, also in Odessa and Dnipro, Kyiv and Kyiv region. Other Sumy region, it's not a secret. The National Police pay more attention on investigation of crimes against civilians. Historically, it happened that the National Police used to work with the people and used to deal with investigation of murder, rape, and that's why we hear the most critical challenge for us is the absence of alternative pre-trial. As for today, just a hope of military, because very often we have a repetition of criminal cases and its additional workload. As for National Police, sometimes there is some competition with the bodies of a pre-trial investigation where we do the same investigation, where we are following the same criminal criminals. It's not effective exploitation of resources. The worst is about emotional cases, when I personally, with our investigator, had to look at mother who for 4 years thought that her son was captured, but he was killed since 2022. I don't want to dive into details who investigated that, but there is such cases, and they are not unique ones. For example, the second critical challenge is the absence of effective mechanism concerning like international search and bringing to criminal responsibility. So we have document something 100 times, can do a nice investigation, but when this process is not over and there are obstacles to that, the justice doesn't work for victims. I think it's a key challenge for us. The absence of resources will always exist. We have mentioned before that we are a unique country which investigates war crimes during the war. And every day we have more and more of such crimes. Concerning new personnel challenges, we will always have them because internal affairs have their own institute where they have their own students who can gain experience from experienced investigators, and they will continue such work because the war is not over. And it's not a secret that it could take 50 years of documenting, 100 years. We don't know what to expect. But I would like to also say that there are such uncontrolled challenges, as it was mentioned, the absence of access to temporary occupied areas. These challenges which we cannot control. But we have improved in our expertise, we have possibility to gain more information, we are supported by public organizations, which I'm very, very grateful for. It's a big advantage talking about those resources which help our investigators. The international partners on a regular basis communicate with us. And as for today, I don't want to talk about risks and challenges. I would like to say some positive tendencies. First of all, we moved forward. And as for today, we using new approaches, like international humanitarian law approaches. And with the help of international partners, we have created procedural rooms, special rooms for doing procedural interviews. We have systematic training for investigators. I can talk non-stop, but I understand we have to keep to a timeline. I would like also to mention that we've learned to communicate between institutions and to find this support from each other, talking about documenting and investigation of international crimes. That's why national police is always ready to participate in different initiatives. And I would like to talk about alternative pre-trial phase, which would improve this process more important.
And also, I would like to mention that currently we have prioritization of criminal proceedings. There are big cases, complicated cases that together with the Office of General Prosecutor General, we drive attention to. Briefly speaking, thank you. And now I would like to give the floor to Alexander Baranov, the Coordination Center Director on Legal Aid. So 44 lawyers, they participated into this research, and for lawyers it's quite a difficult issue to defend such people who are, frankly speaking, not popular in Ukrainian society. I remember the first public case where the Russian soldier Sasha Marin was under the investigation, and the lawyer also was under the big direct and indirect pressure. Alexander, so how do you think lawyers, what challenges do they have? Thank you. Thank you for your question. Thank you for your research. I would say that this research enhances the attention of the society to the problem of war crimes, because if we listen to journalists, they say that the interest goes down from the public sector. So the biggest challenge, I would say, that this is the deontological one and the defense of the accused persons from ethical perspective. So let's not forget that in Kiev regional lawyers association, there is the mentioning about the Kiev Nuremberg process that probably when the lawyers defended the convicted, the accused people in Kiev region. But also, if we talk about victims, yes, there are much more lawyers who want to represent and who want to defend victims. But nevertheless, if we look at the rules of the ethical code for the lawyer takes a decision by themselves whether they are ready to defend this person or not. And also, you see conclusions of the report that not all the lawyers feel that they have enough experience in this regard, and maybe they are a bit apprehensive, because if the lawyer isn't ready to ensure the legal services, they are free to recuse themselves. So today we understand that 98% situation is that there is no client with whom to work and to build up the defense line. I mean, if we have the criminal proceedings in absentia. And today the lawyers takes a decision by himself how to defend the client if there is no client. It's really very complicated because we can evaluate only the evidence that we have about the trainings. Today the biggest challenge is the quite limited amount of knowledge about the digital evidence. If we talk about the international humanitarian law and human rights defense for the last 4 years, a lot of materials have been presented. Lawyers appreciate trainings when there are prosecutors, lawyers, and judges together. For them, it is the possibility to start the communication because there is the gap in communication. It is written in the report and it gives like this common value, added value for all of them. If we talk about victims, because as of today, we do not have the category of sexual violence victims in armed forces. We have just general victims of the crimes against sexual liberty, but quite a few people address with this issue. There are a lot of different factors that can give the possibility or to create a prerequisite for people to come to us. And the Minister of Justice today, as after our initiative, there will be amendments in the criminal procedural code and a new mechanism will be created for the assignment of the representative for the victim. So the investigation prosecutor and courts, they will be entitled also to assign the defendant for victims. Again, still we have questioned what are lawyers afraid of, because they are afraid of communication, because they know that if there will be disclosure of information of such criminal proceedings, there will be a special attitude from social aspect to them. That's why we should raise awareness of people in this aspect, because people will ask why the state spends money to defend the criminal, and if there are no conviction verdict, why the proceeding was done. So we understand that there are a lot of questions from the public sector, and we already should start working with it and raise awareness of people. Also, I will wrap up. I will give the floor to other people, but I would like to say that the lawyers do not have possibility to collect evidence by themselves. What do we have? We have the lawyer, we have the lawyer's assistants, and also investigators who can go to the crime scene, investigate the conditions, so on and so forth. But unfortunately, today we cannot give this possibility to people, to lawyers assigned by the state. It would be so great if some mechanism or institutions would be created about the fact that the lawyers could do something. Yes, we understand they do not have enough skills to ensure and to conduct some investigative activities, but maybe to talk about equality of parties, we should think how to give them this possibility. And also another number that maybe can be of some concern. It is written that there are some lawyers who have the background and experience of more than 3 years, and some of those who have only 1 year experience. But all these lawyers, they are experienced, they are experts, and this is just a new category. Because if we say that they have the experience in war crimes only in 1 year, it doesn't mean that they are newbies, that they just start their lawyer's career. It means that today he took a decision that he or she is ready to come to this category despite all the challenges from the society. Thank you. Thank you, Alexander. Thank you. It's really very optimistic of you. Thank you for it. Konstantin Zadovich, the member of expert council of the Center of Civil Liberties. Thank you. First of all, I would like to say thank you from the Ukrainian Helsinki Union on for Human Rights for their research and for all the investigators, lawyers, and prosecutors who took part into this research. As for me, it's really very important initiative because from one point of view, it gives possibility for society to look from the inside how the criminal justice system is operable in the context of war crimes. From other point of view, people who are inside the system, they can signal for the society about the challenges they face and to have support from the society. I won't give you a lot of time. I just want to say one thing that drew my attention, and maybe that is of small concern for me. And maybe it will be included in some new research. So I'm talking about the question that was addressed only to investigators and prosecutors, whether they see the problems in legal qualification for people according to the Article 438. And it was really very unexpected for me that only 11% of investigators of National Police, they see some issues, and 30% of prosecutors, they see issues in it. So absolute majority of prosecutors and investigators, they do not see here any issues. Why it is unexpected for me? Because I'm interested in these topics for quite a long period of time, and as for me, this is very big part of problems of different depths. For example, how to qualify the cruel behavior with the frontline doctor who was as hostage, who was kept as hostage. So which article here is applicable? Just violation in the framework of Article 438 or in some other legal frameworks? Again, if we talk about the looting of the occupied territory, here again we have a lot of different positions. Some people say that these are that national values are cultural values, or for example, if we talk about some academia literature, that this is the expensive property. Some people say that these are both, and there is no very stable legal practice in the framework of this. Here again, it's a kind, maybe not terra incognita, but very near to it. That's why we should clarify also this aspect. Also, we as legal practitioners and academicians, we do not see in this aspects, because, for example, the Article 438 says that there is the violation of different customs and laws of war, and actually it's not surprising that in procedural bylaws we see also links for the Geneva, Hague conventions as of 1907, but technically Verkhovna Rada of Ukraine didn't give consent to the reference of these agreements, because when they were ratified, the Ukraine wasn't independent. There was only Ukrainian Soviet Socialistic Union, and properly that republic gave possibility about the jurisdiction of these agreements. So I think that maybe today we should very clearly state which cases are and which aspects of these conventions should be included into our legal framework, because I do not think that this is very deep problem, but the Article 438 has a lot of issues to be discussed about the qualification of criminal proceedings and crimes. But from the other point of view, I understand that, yes, we try to, and not we try, we did answer in a very fair way, in a very just way, sincere way, because if what we talk about investigators or prosecutors, they more deal about shellings and attacks, or maybe about the abuse and cruel behavior of the hostages. Maybe they can qualify these situations according to the Article 438. But if we look at a broader context, maybe it's not very broad context. So I think that this is not a very difficult issue, but for me, the most important is not to have, just self-tranquilization for the investigators and prosecutors that they know everything, they are aware of everything, because the Article 438, as for me, has a lot of different questions. And I think there is no person all over Ukraine who can give all the answers to all these questions and issues. That's why if there will be continuation of this research, maybe I would recommend to ask some concrete questions about some concrete cases, concrete situations, about the cases, for example, I gave you, and to see which answers will be there. Because I do think that if we ask about the evaluation of some concrete cases, prosecutors and investigators, they won't be unanimous in their answers about the qualification. And also I think that it would be really very interesting if the same question would be posed to the lawyers about qualification, because here I would say that the results won't be so similar. I think that lawyers, they would talk more largely about the fact that such problems, they exist, as far as I know. Thank you. Thank you. Well, I have the following question. As far as I know, as far as we know, and what I heard, what I read, the Russian soldiers who were in Bucha, 90% of them already were killed. That's why if we say that there is the document about suspicion, because we have collected enough of evidence, but we know that this person is already dead, then criminal proceedings should be closed. So my question is whether we close these proceedings today, because there is almost none of such statistics. There is some general statistics about the closed criminal proceedings, but not separately as for the war crimes, because the Article 438, the Section 10, says that also the relatives and lawyers should be informed about it. So the question whether do we have this problem today? Vladimir, Oksana, can you answer this question? I think maybe they left the room because it's too cold here. No, we're here. Well, we didn't have this question. There is the general response only from the prosecutor general office. That is the supplement, and also the national police answer that there is only the overall number of the closed proceedings. That's why, unfortunately, this question wasn't researched. But thank you so much. It's very interesting. And your second panel gives us some hints for the necessity to continue this topic in the research. So we would like also to include the judicial core about the qualification and further judicial consideration, or maybe the how the cases are returned from the court for the further investigations. Okay, so maybe Mr. Denis, maybe you would do it, because there is the question about these numbers. This is one question, and the second question is, what do you plan? What do you need to change this or that year or next year, or where do you need support to change something? Something that is not up to you, I would say. Thank you. Well, if we talk about the closed proceedings with the death of the accused person, I do not know about the statistics, but I know that, yes, there were maybe some willingness to close such proceedings. But sometimes I know that if investigator or prosecutor, they said that maybe it's not proved that the accused person is dead, and then it wasn't closed, but they are not very numerous. Okay. If we talk about the small number of these cases that were closed, we can talk about the general statistics. So as of 30th of September, we said that there were 185,000 cases opened, and at the end of September, there were 184 proceedings were closed. It means that the cases are not closed. Yes, but here we're talking about the suspect, and they're even less numerous. Yes, but maybe in future I will find out the statistics. Okay, so what about the sectors and directions where we need some help and assistance? I would say the following. All these ways how to develop the system of the enhancement of the system with fighting with the international crimes, we have a separate strategy. This strategy, I do believe that it will be already approved for the years 2026-2028, and then we will work over implementation plan where we are trying to see which concrete events we will do to enhance this general situation.
And we are planning to involve everyone who is interested and relevant. Please participate in such events depending on resources, competencies. This event is going to be public, and you will have a possibility to see what kind of events will be. I don't want to give more details, but there will be 4 main areas as in the previous strategies, a structurized approach to investigation, and all some investigations which have common something in common. It should, in order it would happen in synchronized way to have logics. Second one, it's about strengthening capacities and of those agencies who do the investigations, strengthening those groups and experts who provide us some experience and knowledge where prosecutors don't have enough, and where they implement IT solutions. And the third area, it's the support of victims. A lot of events on improvement of work and communication with victims. And the fourth is like external approach. It's the cooperation with international organizations and national non-government and national and international NGOs. All these areas work, and the list of these events will be in implementation plan to the strategy. But still we'll have this trainings, support, depending on what kind of possibilities people have. We will be interested in future cooperation. Thank you. A very similar question to Christina. What do you need to be changed or in order you could do your work better? Thank you for your question. What we need to get done is, first of all, identify pre-trial phase or separated, because at the beginning of 2022-23 it was a chaos. We could have like gentleman agreements between agencies and with the General Prosecutor's Office. But as for today, it's been the beginning of the 5th year of full invasion and war. We need to have more systematic approach. Talking about the movement, international investigation and research. So mutually with the prosecutor's office, for the last 1 year and a half, we are working on prioritizing, digitalizing aspects. We are working on the creation of a united analytical platform where we can save all this load of information, which is a priority. Advocacy of international crimes, we also started working on that, and we will keep working on that with the colleagues from Security Service of Ukraine and commonly with the coordination of the Prosecutor's Office. It's my vision and my colleagues. This coordination is very important. Also, we will keep training in different categories, and also for our students who could gain this experience in future. It's what we are doing right now. We are going to improve it. Also, I would like to pay attention on survey of 117 investigators. It's more than in the prosecutors and attorneys. So, and I'm very proud of it, because the national police is open, is open and not afraid to be told about their mistakes. And we are working on this. So our aim is to improve, not to lose the connection with international partners, local communities, and just get together. Thank you. Maybe there are some questions. The question concerning authors. Could you remind how many investigators were interrogated? 117. Yes, I want to say such a big actor of this who investigates is a 2/3 of cases. 2/3. And we didn't hear their opinion. I think in the context of a colleague who mentioned there's such internal competition, It would be interesting to find out such statistics, how many cases were brought to court from security forces and from national police. Such kind of competition. Maybe the authors of investigation can tell why they didn't have investigation in security service of Ukraine. When we were looking for possibility of starting such process, we were looking at who could be involved. We were discussing and decided that for now we will focus on the national police and the prosecutor's office in order to evaluate this situation, and maybe for future we were worried not to go something what was to touch something which we were not supposed to touch something. Maybe we shouldn't have access to some data. But if security service are watching us online or are here, we would be happy if you could provide us some feedback. We would be ready to cooperate with them. Other questions? But please speak to the microphone. Good day, Media Initiative for Human Rights. Thank you for investigation, discussion, research. Also, I'd like to mention one question which hasn't been mentioned today. We are in Media Initiative, call it a fragmentation of crimes. I mean, when you read all these 186 conclusions which are in the registration, a big part of them concerning smaller criminal episodes. For example, like Russian a soldier entered the house and raped and so on. Of course, it's proper to investigate such crimes, and investigators have to keep to their laws. But for general picture of crimes, talking about those committed by Russians, it's not the intention of an individual, it's the result of state policies and politics. At the end of previous year, there was suspicion Amur, he was the commander of 64th Brigade, who entered Bucha, and who was awarded by Putin, and we understand that he's responsible for crimes in Kyiv region. But as he personally tortured some civilians. In October 2024, the Article 31 came into force on responsibility of commanders for crimes committed by their subordinates. As the criminal law didn't have it before, but unfortunately we are in the process of monitoring and communication with investigators. We don't see that those crimes were committed after October. This article was applied. Could you comment on this? Thank you. I will start with the first what you mentioned. It looks to work, and the result, it's a number of suspicions. They are, as a rule, unfortunately, are for such individual cases, have signs of systematic approach, because these crimes are being just faster investigated, but the work on a bigger scale is lasting. And the results hopefully will be in near future. What I can remember, we sent to the court case against 5 Russian commanders who were terrorizing Kherson region. And there were a lot of episodes. And in the near future, we'll have more of them because we took some time, we collected data, came up to some conclusions. But it's one of our priorities, the orientation on big systematic crimes and which have signs of state policies. What concerns commander's responsibility, it's a very important question. We've been working with other prosecutors saying that it is very important. But the responsibility of commander is, but all cases, it's the committing crime by themselves or giving an order or their involvement as an organizer or participant in committing crimes. We are promoting this, and what concerns collective responsibility, we have first cases on procedural responsibility. First of all, we have a sentence of Mykolaiv court, which has written down the responsibility of commander relating to Geneva Convention article. There are 2 messages on suspension in Kyiv region, and the references for collective responsibility, and also we are cooperating with our partners from crime atrocity group who we are cooperating with, and we are developing pilot programs which will be scaled up later, and all actors will be informed of them, and it will be possible to use our common experience in those pilot programs. I hope in near future we will get such collective responsibility. So the work is being done, and lately we pay attention a lot to the responsibility of our commanders in the context for prosecutors, investigators. We are trying to adapt them to this meaning, to explain what it is. But unfortunately, we have understood that the command responsibility is the most difficult to improve, and international experts agree on that. There is absence of signs of responsibilities, then we can also go to responsibility. But it's very difficult to prove it. Thank you, Denise. Unfortunately, we have to finish our event. It's pretty cold here, but many people talk about important things. And if somebody wants to give final remarks for 1-2 minutes. Talking about free legal aid, we were not asked what needs we have. Yes, because you mentioned it before that you are planning some bills, and if we talk about increasing the capacities, and we understand that we need trainings, improve our knowledge, and improve communication with the victims. There is one question which we can solve all together, because if we read different reports, we see when judges can talk that attorney defense it was done not of a proper quality. As for today, there is a mechanism in creation of a commission on evaluation of quality and providing free legal aid. And if we have information about such cases, we can address such commissions, and they will investigate if a quality criteria were not kept to. But as for today, we haven't received any any request from any side concerning that there is a doubt on quality of legal aid. Let's talk about that not only in reports in 6 months or in a year after there is the investigation was over. We should do it in a relevant time. This mechanism exists, and it can give recommendations or recommend to break the agreement. We understand that quality of providing legal aid is very important. And the last moment, as for now, this question hasn't been resolved, but we can see when partners organize trainings abroad, we know that we can't go abroad, only 15% all over number. It's sad, but there are attorneys that are mobilized or in the army. There were no cases such attorney was mobilized in the process, but it looks, if we talk about equality, if we see such important cases and criminal cases, so if attorney could be provided possibility to do his work, not to be mobilized at any moment. Because if we talk about prosecutors, they have such possibility. First of all, it was mentioned about the attorneys and not involvement in investigation. I have spent a lot of time thinking who shouldn't be involved to such investigation, representative of suspected or other side. It sounds not very well, but I do not understand very well what it is about. What concerns today's event, I want to say thank you for these results, which reflect this picture and what society should be aware of, and those agencies who deal with that, and this information has to be used properly. And on our side, we would call for all interested for cooperation, and I think only mutually, we could work on evocation of international law. Thank you. As to this moment, we are closing this event. Thank you, the EU and the Renaissance Fund. Thank you for this event, this research. It gives birth a lot of material for future researches. The question is complicated. Sometimes the work of investigator is not always visible, but there are a lot of investigators who were killed while doing their work. So the society would have to support their support. We have to work on it for decades and support this work. So thank you for participation. We will send a presentation in both languages. You will get them today. So thank you and best wishes, and have a safe days. And having these investigations accomplished done by Russian Federation in Ukraine.